to introduce the first panel of the day. Formerly a Senior Additional Solicitor General of the Attorney General's Department and the former Director General of the Commission to Investigate Allegations of Bribery or Corruption, or ciaboc, Sarath Jayamanne of the President's Council is a leading criminal defense counsel with a reputation as a versatile and well-respected senior prosecutor. Welcome, Sarath. Our second panelist this morning is Dr. Subhani Keerthiratne, head of the Financial Intelligence Unit, where she has been active since 2017. She has over 22 years of experience in the central bank, particularly in areas of financial intelligence, legal, economic research, supervision of non-bank financial institutions, and exchange control. Welcome, Dr. Subhani. We are also joined by Disna Gurusingha, Assistant Director General of ciaboc. With a Master's of Law in Criminal Justice Administration from the Open University of Sri Lanka, she has served the Commission for over 16 years. Welcome, Disna. Some of you might have also seen Professor Samarajiva, founding chair of lirneasia, in action just yesterday, but we are pleased to have him back here with us as moderator on this panel. Over to you, Professor.
I've got a bit of catching up to do, so let me move straight into the conversation. We are talking about, we've had sort of sociological approaches to corruption, but I'm here with, in my view, the best expert in the country on the subject of corruption in Sri Lanka, Sarath Jayamanne. So I will focus this on the legal issues. So we can talk about corruption till we are blue in the face. There are all these people who listen to parliamentary committees and say, oh, that corruption has been proved, that has been proved. But that's not true. Corruption is a criminal offense. Bribery is a criminal offense. Money laundering is a criminal offense. And there are new offenses connected to asset declarations. We will focus on the legal definitions that are likely to put people in jail under Sri Lankan law. So that will be our focus. The situation in our country today is that we have a new law from 2023, the Anti-Corruption Act, which includes within it what we used to think about as the ciaboc law, that is the Bribery and Corruption Commission law, and the Asset Declaration law. So those two are now folded into this new act. So we will be talking hopefully about both of those. Then there is the money laundering legislation that comes from some time back. We will also be talking about that. We will hopefully be saying something about another piece of legislation that you may have seen in the slides that was enacted in April 2024. No, it wasn't enacted in April 24. We are running late on that act. That is the Stolen Assets Recovery. I believe the draft is complete, and we may be able to say something about that. So that's the legislative part. In my view, when I came to Sri Lanka back in 1997-98, I found a piece of legislation that I had to implement. And I can remember at one point, I called the senior staff and I said, what is this? Which of these sections have you guys used? The legislation had been in place for 7 years. And there were entire sections. There was a section on public hearings. There was a section on public notice. There were license conditions violations. There were all kinds of provisions in that law. And I said, what have you done with this? What has this organization done with the law that it was given? And I said, now remember, we have muscles. And we are, in the next few months, we are going to exercise those muscles. We are going to go section by section. We are going to have a public notice proceeding. We are going to have public hearings. We are going to have a license condition proceeding, violation proceeding. We are going to exercise the muscles that we were given, right? And if necessary, if we think that some of the restrictions were too harsh, We are even going to propose ways in which we can do things like forbearance from tariff regulation, which we did within the bounds of the law, right? So I think the implementation part of all these complex legislation that is coming in is extraordinarily important. And in my questions, I will be focusing on that. So that's enough for context. May I ask Sarath to say a few things, hopefully within 5 minutes, so that people have a sense of what your main concerns and ideas are, and then we can focus the questions on those.
Thank you very much, Professor. We need to understand key words before we enter into any discussion. What is bribery? Bribery means if you are a public official, if you accept or ask for any gratification, that is called bribery. What do you mean by gratification? It can be money, it can be weekend journey somewhere, it can be a loan. Now, even the asking for sexual flavor, that is also part of gratification. So earlier, only the public officials are responsible for bribery. Now, with the new enactment, even the private sector entities are guilty if they ask for, if they accept bribery. Corruption. World over, the word corruption is used in various forms. But in Sri Lanka, corruption has been defined. In Sri Lanka, bribery is a separate offense. The corruption is a separate offense. What do you mean by corruption? Corruption means if you are a public official, if you are going to take a decision, and if you are taking a decision with a criminal mind. What do you mean by criminal mind? You take this decision today in order to give a benefit to a third party, or in order to cause a loss to a third party, or in order to cause a loss to the government, or benefit yourself. With that criminal mind, if you take a decision, that is called corruption. Then we have asset declaration. What do you mean by asset declaration? Asset declaration means senior public officials are required to submit their asset declaration. Why is that? Under the Anti-Corruption Act, as well as the previous Bribery Act, there was a presumption. What is the presumption? If I am a public servant, if I have assets and so many expenses, that is not compatible with my legitimate income. There is a presumption that the deficit has been acquired through bribery. When conducting such investigation, the first and key document the investigators would look into is the annual asset declaration form. For the last 75 years, all these senior public officials, they have been submitting this asset declaration form manually. Now what we have done, we have prepared, even with the support of our professor, electronic asset declaration form, and even the new law provide for that. In the new act, there are other additional offenses like conflict of interest has been recognized as a criminal offense. Then, in the new act, the commission has been made fully independent. They have the power to recruit the experts, whoever they want, they can recruit. Then the money for their resources, they don't need to go to the treasury. They can submit it to the parliament. Through the parliament approval, they can get the money from the treasury. Those are the key changes we have made. In addition to that, for the first time in our history, the Bribery Commission has been vested with the power of prevention. What do you mean by prevention? You don't need till an offense is committed. Prior to the committal of an offense, there are certain loopholes in the system. Why these offenses are committed? Because the loose system, procedures, and practices. The Bribery Commission has the power to look into each and every government department, government authority, and tell them rectify these procedures, have this online system, and the Bribery Commission have that power, and this is our additional power that they have been vested with. I think those are the key things that we have introduced. There are other things during the Q&A. I would answer those things.
I know Sarath can talk for about 3 hours on this without a break. But I'm thankful that you have just summarized it, because this idea is to focus the issues so that you can ask your questions in a focused manner. Dr. Keerthiratne, it's the same for you. People don't know much about the Money Laundering Act. People don't know about the FIU. Tell them.
Good morning, ladies and gentlemen. Thank you very much, Professor. So actually, I would set the context first, because money laundering is basically you disguise the illicit origin of illegal proceeds in order to enjoy it or to give it an appearance of legitimacy. So what does it mean? You earn money from some illegal activity, you want to use it, so you distance yourself and that money from that criminal origin. So that process is called money laundering. Actually, in this context, we are talking about three areas: money laundering, then terrorist financing. Financing of terrorists, terrorist organizations, and also terrorist activities is called terrorist financing. Why do they need money? For their sustenance, trainings, and also to conduct terrorist activities. So in these both instances, these are like vicious cycles. If we take out the element of money, we can curb these offenses. And we are talking about another area, that is rapid construction of weapons of mass destruction. That is the proliferation financing, because we are all aware with nuclear weapons, biological weapons, they can cause a severe damage to human and physical capital in a very short period. So world doesn't want unauthorized individuals, organizations, and countries to have them, to purchase them or possess them. So to combat them, they have proliferation financing combating also. So in this context, the global policy setter is called Financial Action Task Force. They have introduced 40 recommendations. They are focusing on combating money laundering, terrorist financing, and proliferation financing. So countries should have necessary legal framework, institutional framework, and also our competent authorities should have necessary powers and procedures to combat money laundering, terrorist financing. That is not enough. That is only the technical compliance with respect to 40 recommendations. But we should implement our legal system. That is effectiveness. Our AML-CFT system, anti-money laundering and countering the financing of terrorism system, should actually yield expected results. So this is called effectiveness. This is measured by FATF through its regional bodies. In our case, it is the APG, Asia Pacific Group on Money Laundering, from time to time. So through mutual evaluations. Sri Lanka has faced 2 mutual evaluations before. Our third mutual evaluation on anti-money laundering and countering the financing of terrorism is due in 40 weeks, next year, March 2025. During the first 2 instances, after the evaluation, Sri Lanka was grey listed. We faced a lot of negative repercussions because of grey listing. Because even though FATF does not ask other countries to take countermeasures against grey listed countries, other countries view grey listed countries as high risk countries. So they are de-risking. So that means they consider them as high risk countries. So grey listed countries, individuals, institutions, not only that, financial institutions, they face higher scrutiny, enhanced due diligence. And also our correspondent banking relationships are at a stake. Sometimes they withdraw them, reevaluate them. They don't enter into new correspondent banking relationships with financial institutions in grey listed countries. And we have to face, we are a borrowing country. When we go for debt, international debt, we have to face higher risk premium, higher interest rate. Our borrowing costs go high. Then credit rating will be affected, sovereign rating will be affected. With all this, we cannot go back to the grey list in the third time. So this is not only about that. Actually, the 2018 IMF framework for extended fund engagement, it has a specific pillar out of 6 pillars on money laundering and terrorist financing, which specifically talks about international cooperation, criminal justice, again, preventive measures, and also uh, transparency and beneficial ownership of companies. So these areas are very important. Because of that, anti-money laundering measures, countering the financing terrorism measures, not only important for our country to face the mutual evaluation, but also to make our country a better place as suggested by this diagnostic report.
Thank you very much. I think I emphasize the importance of implementation. You can have laws, you can analyze the laws, you can find the gaps and the mistakes and the shortcomings, and we can fix them. But unless we implement, we have a problem. I hope you'll talk about the implementation at the Commission.
Well, thank you, Professor, and good morning to you all. At the ciaboc, now we are undergoing a total change from the previous ciaboc we knew, and the ciaboc in terms of the new Anti-Corruption Act. So the commission, comprising of 3 commissioners and the Director General, they are the top leaders of the commission, and we have the prosecuting wing and the investigators as well. We have a prevention unit to take preventive measures, and the ciaboc's work plan includes prevention, prosecution, and investigation. Now, the Anti-Corruption Act contemplates the establishment of a separate unit called Assets Declaration Directorate, where the ciaboc will be the central authority under the Act. Ciaboc is now in the process of restructuring the institution and drafting and preparing regulations, rules required under the Act in order to effectively enforce the law in future.
Thank you. Let me have a follow-up question on you, because you actually didn't take your 5 minutes. Now, Sarath talked about the asset declaration, the new approach to asset declaration. And I'm going to emphasize this, because even today, almost a year after the law has been passed, people are talking to me in terms of the old asset declaration law, which had a certain completely different philosophical basis. The new asset declaration, specifically applying to, say, members of parliament, is mandatory. They have to hand over the asset declaration along with with their nomination papers. Earlier, it was a press release. It was those who wanted to show that they were doing this could have a press conference and talk about it, but it was voluntary. And asset declarations could not be used by people, right? They were just there to be used in a future prosecution, as Sarath mentioned. But the new one says it has to be online. There has to be a website. My question is, where's the website? We are talking elections.
Well, Professor, I think you know better than me how challenging it is to have an electronic system as such in place, given the budgetary capacity of both our government and the institutions. And this electronic assets declaration contemplated in the Act contain lot of features. So it is not going to be something available on market where we can go and buy then and there. It will be, it has to be a tailor-made one. So we need to go through a long process.
Have you got the money?
Well, the Commission is now taking steps to secure money from the government, and we in fact gone before the donors asking for assistance. The Commission is to place concept notes and the necessary papers to be with the stakeholders, so that the Commission will be able to take measures to have this electronic asset declaration system in place as soon as possible.
Right. So now we know that in fact, this year in 2024, which is the election year, what we are going to get is an interim solution, which I believe the Commission is working on. We are going to get an interim solution so that we can still obey the law and make sure that the, well, over 1,000 whatever people and over 50 whatever people are going to put their nomination papers for the general election and the presidential election. God forbid if the local government election would be called, right? We'll have 10,000 people submitting nomination papers. We'll have to have some interim solution for that. So I'm confident that the Commission will come up with an interim solution, but you know that we don't have the resources, and for people who know government procurement, particularly in this area like me, which I think it's completely broken, you can expect it to take a long time. Right. So, one question down. Now, is there someone here who can tell us about why we haven't had a successful money laundering prosecution in this country?
Yes,
Yes.
yes, Professor, you are correct. Because the legal framework has three enactments. Basically, Prevention of Money Laundering Act number 5 of 2006, which was amended in 2011, and also the Financial Transactions Reporting Act, which covers FIU, Financial Intelligence Unit, and the powers and functions, and also the obligations of reporting institutions, and also the Terrorist Financing Act. But with these two acts, we have so far, at the moment, we have about pending 60 prosecutions. And
Could you repeat that? Pending?
60
60
prosecutions. Wow. And also only around 15 convictions.
15 convictions have been obtained.
A few years ago, it was limited to 7 or 8, but during the recent part, it has increased. But given that these legislations have been there for a long time, I think it is not sufficient to show our effectiveness. And also, as a country, we need to investigate, prosecute, and convict criminals. And we need to take away the illicit proceeds from them. So it has not been done so far successfully. There have been a lot of difficulties for that, because this money laundering is a complex offense. Because in terms of Section 3 of the Prevention of Money Laundering Act, it says that if any person knowingly or having reasons to believe engage in a transaction related to a property which is derived or realized from any unlawful activity or proceeds of unlawful activity, and also if someone receives, possesses, conceals, disposes of, or he is bringing into Sri Lanka or sending out of Sri Lanka or investing in Sri Lanka any property which is related to unlawful activity or proceeds of unlawful activity, then it is an offense. And also there is a rebuttable presumption. If you cannot explain your wealth, then it is presumed to be earned from money laundering. But having all these provisions, still we are in the infancy when it comes to implementation of our legal provisions. So we hope that in the near future, actually we can see it from all the stakeholders, especially investigators, prosecutors, and also from the judiciary. We see the commitment. Hopefully we will see more and more convictions.
So is it the Attorney General's Department that is responsible for money laundering, for initiating money laundering cases? Or is it ciaboc? Or has that changed?
Actually, ciaboc is dealing with corruption and bribery and also with asset declarations. So for money laundering, it can derive from any unlawful activity. Now the FATF has identified about 20 predicate offences, and we have also defined in our enactments certain unlawful activities. So one of them is bribery and corruption. So they are intrinsically related. If we want to curb corruption, we want to proceed money laundering aspect, money trail as well, because it enhances the transparency of our financial system, and also it facilitates detection, prevention, and also investigation, prosecution, conviction of corruption and both money laundering cases. And it will promote integrity of public sector, and also it will protect our designated private sector institutions from abuse. So corruption is one of the unlawful activities for money laundering.
You want to add something?
Yes, Professor. I think with the enactment of the Anti-Corruption Act 2023, now the ciaboc also is empowered to investigate into money laundering when the predicate offence is one of bribery or corruption or an offence under the Anti-Corruption Act.
You can initiate the prosecution also.
Correct.
Okay.
And also, one of the other reasons, if I may say, for the absence of these money laundering successful prosecutions, there was a huge challenge with the Commissions Act then, where there was a secrecy provision. The ciaboc could not share any of the information received by the ciaboc during their investigations. Now it has been relaxed, and now the ciaboc can even exchange information between the enforcement authorities, so as our authorities can get together in order to achieve better cases.
I know Mr. Jayamanne can speak to any and all of these subjects, but I'm going to ask you, Sarath, is there a gap that has to be filled by the stolen assets recovery legislation? Why are we doing that?
We'll take a simple case of theft or robbery. We charge the thief or the robber. Then what will happen to the robbed money? First, you have to prove the case in a criminal court and prove beyond reasonable doubt that this person has robbed the money. Then there has to be a conviction of robbery. After the robbery conviction is only, court will decide this robbed money, probably recovered from the robber, whether to whom that is going to be handed over. That is called disposal of property. So without having a conviction, you can't do anything with the robbed money. That is the general law in this country.
She talked about a rebuttable presumption.
Yes.
Yes, and also there is another provision in Money Laundering Act, Prevention of Money Laundering Act, Section 3, subsection 3. It specifically says there is no need of having a conviction for the predicate offense to proceed with the money laundering offense. So when it comes to money, this I really completely agree with Mr. Jayamanne. That is the norm. General law. However, there are special provisions in the Prevention of Money Laundering Act to overcome this issue.
Sorry, Sarath, I won't interrupt you again.
No, I want to systematically explain to the audience. However, the anti-money laundering law was introduced with this difficulty. But the problem in the anti-money laundering piece of legislation is the prosecution has to prove this money has been laundered. Without proving the element of laundering, you can't prove the prosecution. Then though there's a presumption, on paper it is so sweet. Always we get the feeling the moment the case is filed, the presumption would be applicable. In practice, it won't. Why? Just because the perpetrator has assets, court is not going to draw that inference. It is illegally obtained assets. Why? There is a duty cast on the prosecution to show this particular the accused has the means and the capacity to commit a particular criminal offense of bribery or corruption. Without having that link, you can't draw that inference. That is one of the reasons I know the acquittal of a particular politician in the recent past. So therefore, this difficulty is in the Anti-Money Laundering Act. Now what we have done? Now we are going to introduce a Proceeds of Crime Act. There was a committee consisting from various stakeholders. We sat for more than 1 year, headed by Justice Yasantha Kodagoda, and we prepared a report by the 10th of April last month and submitted to the cabinet, and cabinet has approved. Now the legislation is being drafted by the legal draft persons. What is the purpose of having proceeds of crime law? Proceeds of crime law means basically if a particular person has particular assets, and if the investigator thinks there's a reasonable suspicion this has been acquired through a proceed of a crime, that means he can basically start an investigation after getting the necessary approval. During the course of the investigation, they will collect material, and you have to give an opportunity to the accused to explain how you have got these assets. If he fails to explain, what will happen? He will be prosecuted for in possession of proceeds of crime. So once you prosecute, once there is a conviction, what will happen? After the conviction, there will be a basically forfeiture of those assets. Then we have introduced a new mechanism also. There are certain cases you can't prosecute an offender, but we know this is ill-gotten money. Then what are we going to do? We are going to have a non-conviction based prosecution. What does that mean? We are going to have a conviction against that particular property. Why? Then the prosecution need to prove the case only on a balance of probability. We have an asset and we have evidence that there is no legitimate means of securing these assets. Then what happens? We go for a non-conviction based prosecution. After the non-conviction based prosecution, that asset can be forfeited. So that has been introduced in the new system. So with this law, once this law come into operation, I think all the difficulties we had under the Criminal Procedure Code, all the difficulties we have had under the anti-money law will be reduced. Other feature is in this new Proceeds of Crime law is the investigators have been given so much power, and when they conduct investigation, they can basically go and seize the property. Not only seize, they can give an order called some kind of a prevention order, restraining order. They can ask the perpetrator not to do anything with this property, not to transfer this property. Thereafter, you can go before the courts and take a basically legal freezing order. Why? We want to keep this property intact till the final conviction. Once we take the property, what are you going to do? We have to manage the property. Take an animal farm, take a factory. Just because investigators go and seize, can they manage? No. There has to be a management authority comprising of experts. That is also provided under this act. Then when you introduce these acts, you have to be mindful. There are competing interests. There may be innocent receivers. Their rights have to be protected. Sometimes overzealous investigators go and arrest this property, seize this property. You have to protect those. So there are certain competing interests, and we have looked at the law in UK, Australia, and US. We have compared those laws and prepared this law at the moment. And once it is tabled before the parliament, or once it is being discussed by the other members of the society, I think still it is open for more deliberations.
Now, my plan was to open it up to your questions. I don't see any microphones ready. They are ready. So if you have any questions, please raise your hand. all these bright lights are blinding me, but I can more or less see where the hands are. I don't see any hands yet. Yes, I see a hand right in the back.
Hi, thank you.
Brief questions, please.
Yes,
We have 16 minutes.
Okay, I only need 30 seconds. Corruption is not so it's great that we have all these rules and the systems that we're trying to put into place. But at the same time, you also have to ask why there is corruption coming. Because if you don't find the root cause of the origin of corruption, you will not be able to finally solve it. One important thing is the fact that we don't pay our politicians and our senior executives in government anything close to a reasonable salary. So how do you solve corruption properly without fixing that?
Yeah, that's a very interesting question which I have thought about.
Yes, same question Mr. Lee Kuan Yew had in 1950s, chicken and egg solution. What did he tell the public servants there in Singapore? He said, I don't have any assets, any resources in my country. Sri Lanka, Ceylon, they had so much assets and resources. The only asset I would have, the integrity of the public servants. I will only recruit on the basis of meritocracy. Then I will follow the pragmatism also. First, show the public servants their capacity and they will be promoted only on merits. And once you come to a particular level, definitely I am going to increase their salary. Their salary must be in par with the private sector. So for the time being, we have to make a sacrifice. Not only that, no, you understand, we have roughly 1.5 million public servants. I think now it may have come reduced to a few lakhs. That means if you walk on the road, if you meet 17 persons, one person is a public servant. In Singapore or Hong Kong, if you walk, you have to meet 70 persons to meet a public service. So that shows our public service is overcrowded. We hardly use our online systems. So therefore, what is the most important thing is we must reduce general public meeting and seeing in eye to eye the public servant to get a relief. Most of the reliefs, 95% of the reliefs public asks are in general nature. So there has to be an online portal. There has to be an integrity officer in each and every public department, and he must see to it with the support of the leadership what changes should be brought in to minimize the corruption in that organization. So at the moment that is not happening, I think what is the best solution is the leadership of each and every government department. We are very short of leaders. They must be having academic qualifications, but leadership skills, and they are really thinking pattern, and their will. I don't think they have really will to reduce the corruption in their particular government department. So we have to encourage. If you take Scandinavian countries, why they are less corrupt? In their genes, in their DNA, they have these value-based systems in their genes. They don't need very strict laws. Unfortunately, we don't have such values in our system. That is why the moment we see an opportunity, we are prone for bribery and corruption.
Yes, I do have another hand. Yes.
Hi, Professor.
Brief question, please.
How does asset recovery work outside the jurisdiction of Sri Lanka? Let's say Dubai, for instance. Popular destination.
Excellent question.
Yes. Those are very complicated procedures. In the new Process of Crime Act, we have provided for that, because we have to have very good understanding with the foreign investigators and the foreign law enforcement agencies. We have to enter into a MOU, and we have to provide for that. All depends of the will of the foreign country. If the foreign country is not assisting, what will happen? Nothing would happen. But in addition to that, we need to have expertise. We need to have experts to recover assets stolen in outside countries. In most countries, when their assets have been looted out, they seek the assistance of experts. There are experts in the World Bank, there are experts in the UNODC. We need to get their support. For example, in Philippines, Marcos, he has looted assets. Then this government has sought assistance. It took more than 3 decades to recover the assets. It is a nice, sweet word to hear recovery of assets, but international that happened. Even in Uganda, their army commander has been prosecuted. He has looted some money out of Uganda and stored in other Western countries. Even with the assistance of the experts, it took more than 2 to 3 decades to recover such assets because internationally some countries then they don't give their wishing and the best support to recover such assets, and reasons are obvious.
Dr. Keerthiratne, you have anything to add to this?
Yes, Professor, thank you. I think interagency coordination and international cooperation is very, very important in this area. Especially, we need to conduct joint investigations when our domestic investigators look into maybe asset recovery, some sort of investigation, then they need to seek support of their foreign counterparts. Then it will be a joint investigation. And also, as highlighted in our Financial Action Task Force requirements, international cooperation is very, very important. I think
So do we have this
we have
already?
We have up to a certain extent because we have amended our MACMA, the Mutual Legal Assistance in Criminal Matters. So we have covered the applicability of countries. Now we can have on reciprocity basis and also we have this international cooperation mechanisms in place.
Now, there are many people who keep talking about stars as a mantra. We have this habit of thinking that some acronym is going to solve our problems. What are your views on stars?
I think stolen asset recovery, I think best person would be
Right.
Mr. Jayamanne, because
Yeah,
with that initiative only the Proceeds of Crime Act actually was initiated at the beginning.
This discussion we started in the year 2017 or 2018. There was a task force assigned to draft the Proceeds of Crime law. We almost drafted the policy paper. Then what happened in 2020, there was a change of the government and it did not take place. Now only last year, the Honorable Minister has appointed this new committee. We worked nearly 70 days. We are no longer public servant. We didn't ask for a single cent, but still we worked for 70 days and now this has been drafted, approved by the cabinet. I am hopeful it will come before the parliament, before the elections.
Thank you. I have a question from
Yes,
the front.
thank you. Two quick questions. First to Disna, can you talk a little bit about the prosecutorial arm of ciaboc? To Mr. Sarath Jayamanne, can you relate or narrate how you got the former Chief of Staff of the President?
I will explain the second question this now, with your permission. The reputation of an organization, anti-corruption organization, basically depends on how effective in catching big fish. When we got this information 3 months prior to the raid, I must congratulate my team for keeping that secret. We are dealing with the Chief of Staff of the President's office, and we are dealing with the chairman of another government corporation. Why we were successful? We were successful, our investigators were good, their integrity was impeccable, but more than that, the will of an Indian national, the businessman, he had the backbone and the courage to come before the ciaboc and lodge a complaint? I'm repeating this question to the public sector in this country. How many businessmen in this country would come to the ciaboc and lodge a complaint against the politician? Hardly, hardly, hardly. So we want our country to be corruption free, but the private sector, they never come forward. Thanks to that Indian national that we were able to get the information, and when he came, he had already recorded certain conversations he had with these two accused. Already part of the bribe had been given. Once they came to us, we can't just rush for investigation. Why? If we arbitrarily start an investigation, there will be a fundamental rights case against us. So then we very patiently waited for 3 months. In between, they had another discussion. The two accused had another discussion with the complainant in one of the restaurants in town hall. Our officers went there and covered that. Then on the day of the incident, from time to time, they were changing the place. They were changing the hotel. Why? They don't want this to become informed to the ciaboc. They finally selected a hotel close to the presidential secretariat. We were worried. Once they take the cash back, once they enter into the president's secretariat, there will be a lot of commotion, confusion. We did not agree. Ultimately, they agreed with Touch Samudra. So our officers, they were waiting in the car park. The complainant brought the money and kept in the car park. And first the two accused and the complainant went to the lounge and had a soft drink. And the two accused got some empty cake bags, cake covers, and they came to the car park. The complainant got the cash, and the cash was given to the complainant, one of our decoys. He dressed himself looks like an Indian. So he handed over the cash, the bag to the complainant. Then complainant handed over the cash to the first accused. Then he got into the car of the first accused and start counting. Why? Two accused have to distribute themselves. Then only signal was given, our other team came and grabbed. This happened around 4:30. That is a very ironic day. That is the first day we started a national campaign to prepare national action plan for anti-corruption. Our first meeting was held in the morning in one of the hotels in Battaramul. Very same day, this detection was made. Then what happened between midnight, before the midnight, the suspects were produced before the magistrate. But I must say, since you asked this question openly, I must say, then the president, he did not know about this thing. Even after the incident, he asked me whether it is genuine. I said, yes, it is genuine. That's all. That's all. He never interfered with us. That I must say on record, he never interfered with us. So that is the type of investigation we did. Again, the cooperation of the private sector is very important.
Yes, Professor. If I may continue from where Sir stopped, I think he happened to be the leader. When you speak about prosecution, it starts with the investigation itself. So there should be a strategy to be followed, and there should be a leader to lead the team. And then luckily we had this eminent prosecutor from the Attorney General's Department as the Director General. So we did a successful prosecution there. As far as the prosecution wing of the commission is concerned, so far we had the recruitment procedure that we adopt to recruit other public servants. It's the similar. So you see these complex corruption cases cannot be prosecuted by officials recruited in that way. So that is why this operational independence is there in the Act. So now the Commission is considering rules and regulations relating to recruitment of best prosecutors as well in order to have successful prosecutions in future.
Well, okay. I
You
think,
are- you are
see, I'm
asking-
down to about 2 minutes.
Yeah,
So
you are
please.
asking for volunteers, right? On some of these complex cases, that if anybody wants to come and help.
Correct, correct. We need the assistance of the society. It's not a single battle by the ciaboc. It should be with the assistance of the whole society, Sri Lankan society. Your assistance is required.
May I also add 1 minute?
Yes, please.
Now, ciaboc has the power to recruit any investigator, any expert, even on contract basis.
It has the power, Sarath. Does it have the money?
Yes, that's a different matter. Because earlier we could not recruit going beyond the public administration circulars or the treasury circulars. Now, like other countries like Fiji, Hong Kong, the ciaboc has been vested with the powers to recruit even on contract basis, on time-bound basis. Even the private sector experts, they must now join the ciaboc rather than asking to have a clean country. So that power is there even for the prosecution. Good prosecutor won't be born overnight. They have to have at least 20, 25 years experience. And they are successful lawyers in the private bar. So therefore, you have to pay them sufficiently. Even in other countries, they recruit private sector lawyers to do the prosecution case. Now the ciaboc has been vested with that power, depending on the seniority, depending on the experience, depending on their market charges. Ciaboc can, of course, can pay a reasonable amount. I'm sure there are lawyers even in the private bar. They would come and do the prosecution.
So thank you very much. It is said that I have one of my primary religions is fixation on time. And when my time signal is coming technologically, I'm even more subservient. So I'm so apologetic. I'm so sorry. I cannot take any more questions. We are done. But this is the sign of a good session. And I thank you for that because you have raised enough questions that these people want to talk to you. I hope you won't leave immediately after this. So please ask questions from these gentlemen and ladies. That's the best we can do. This has been an excellent session. I thank you. You have surpassed my expectations. Thank you very much.
It's my pleasure to have been invited.
Thank you.